Allowed with the consent of the other side. That is item number 94, my lord. 94, my lord. Okay. I'm still there. A short accommodation, my lord. I am some personal difficulty. I am for the writ petition of railway. Okay. My lord, may I take a
And Council Mr. Chakravarti
Yes, sir.
submits that he needs some time to prepare the matter. The other side has no objection, list of 2 weeks or 4 weeks. Let it come out 4 weeks. Okay.
Ma- okay. Lordship, item number 80, my lord,
Yes.
hearing matter. But due to my personal inconvenience, matter may be taken up on 2nd of May, my lord, or 4th of May, my lord.
You are for the appellant
Lord.
and counsel for the appellant submits that he needs time to prepare and argue the matter. List after 3 weeks.
Lordship, date may be reached, my lord.
Let it come, sir. Let it come. You could have argued it today. Let it come. The rest will list it.
Lordship,
Okay.
problem.
Yes.
Back to mention item number 91.
90, yes.
As for respondent number 5, with the consent of the other side, Lordship, the Ganguly personal difficulty today, taken up after 2 weeks.
It is stated that counsel Mr. A. Ganguly representing the respondent number 5 has some personal difficulty today. And thus a prayer is made to adjourn the matter. List after 2 weeks.
May I please, your lordship? I beg to mention item 89 of daily list, your lordship. Senior is newly engaged. Lordship may kindly take it up after a week.
You are for the appellant.
Yes, your lordship.
MS so and so submits that senior advocate Mr.
BD Das.
B.D. Das. His name is there.
Yes, your lordship. I'm praying on behalf
Has been engaged to argue the matter, but he is not available today or what?
No, he's not ready, your
He is not prepared with the matter. And a prayer is thus made to adjourn the case. The other side has no objection. List after 2 weeks.
Obliged.
May it please your lordship. Lordship, I beg to mention item number 92, lordship. With
92.
consent of the respondent, lordship.
Why? It's your own matter.
Lordship, 22 matter. Yes, lordship.
Hmm?
Yes, 22 matter.
You are MSM Nirola.
Yes,
So it's your own file. Why you want to get adjournment? Argue.
some difficulty.
What is the case about? Let's see.
Lordship,
We'll surmount the difficulty together. What is the case about?
lordship, we are appellant are agreed by the office memorandum, lordship, where the promotional avenue from grade 4 to grade 3, the education qualification is prescribed as graduation, lordship. So we are agreed by that, lordship.
Okay. Very well. MSM Nirola representing the appellants appraised for time. The other side has no objection. List up 4 weeks.
Obliged.
Yes.
Please, my lord. My lord, a prayer for requisition. My lord, in item 87 of today's daily list, we have filed the affidavit in reply yesterday. We have served the copies. My lord, kindly it be brought on record.
You're for the state
My lord, I am for the appellant, my lord.
appellant. Then counsel Mr. So and so submits that he has filed affidavit in opposition in the registry. The same be brought on record. The appeal be listed for argument for hearing after 2 weeks, after 3 weeks.
My lord, today, if possible,
Today,
during the course of the day. My lord, affidavit in reply, my lord.
affidavit in reply, that is rejoinder affidavit.
My lord, my lord.
Today, get the affidavit, we'll see.
Highly obliged, highly obliged.
So, Lordship, I beg to mention item number 81, Lordship. Mr. Engaged counsel, SP Roy, due to personal difficulty, cannot appear to be your Lordship. Kindly fix the next Thursday, Lordship.
It is stated that arguing counsel Mr. SP
Roy.
Roy is not available today. Is not in a position to argue the matter today.
Yes, Lordship.
And a prayer is made to adjourn the matter. List up to 2 weeks. The other side has no objection. List up to 3 weeks.
Lordship, with the consent of the other side, I beg to mention item number 102, Lordship. There is some difficulty on the part of Mr. S. Bhattakur. He had to leave for Sipsagar due to some personal difficulty, Lordship.
It is stated that counsel Mr. S. Bhattakur is not available today.
Yes, Lordship.
And the prayer is made to adjourn the matter. List after 3 weeks. Okay.
Obliged,
Or they all three will go.
obliged, Lordship.
Ask Mr. Chakravarti whether he is, what is his reaction on this? All right, start.
Item number 1 to 74, along with item number 100.
Lordship, in this matter, Lordship, yesterday I given a adjournment memo, your Lordship. I've taken consent from the senior counsel, but I have not taken.
Oh,
consent
but
from all
you have
the-
not taken consent of the court. It's too much. We have bunched the matters together, listed them for disposal. And you are asking for an adjournment. Why?
There's some difficulty.
Yeah, writ petitions of 18, 17, 19. What difficulty? Difficulty will remain till you argue the matter. Once you argue the matter, the difficulty will be with us. You just shift the burden onto us, onto the court. This is not fair. The matters
Really
are listed at
apologize.
top of the board.
Really apologize, Lordship, for that matter.
What is the controversy? Let us know. Briefly. You are not the only counsel in the bunch.
Yes,
There are many more
I-
counsel.
I
Let the
appeal-
others argue.
I'm appealing only in 3 items. My
So
senior
let
is
the
appealing
let the
only-
others argue.
Yes,
You are in which item number?
55, 56.
All right, let the items number 1, 2, and 3 be called out
Yes,
first.
sir.
Let's see. Yes. Yes, 2. Item number 2, Mr. R. Islam. You are prepared?
So this matter is supposed to argue by my senior Malad UK Nayar. Yeah,
So where is Mr. Nair? He must we must be in the court.
yes, Malad.
Call him.
Another court Malad.
All right, let him come.
Yes, sir.
All right, in the meantime, we'll call out other cases.
Yes.
Mr. A.K. Sarma. Mr. A.G., what are we supposed to do? Yes. It's not fair. There's a bunch listed. The council knew very well.
Why after the vacation this matter will,
Yes,
after the vacation?
that was the prayer made by the other side. That they'll be arguing it.
In fact, these cases were argued 3 times.
Yes.
But
What is the- what
before
is-
this went for the first time?
What is the broad controversy? Let us know.
Well, they are challenging various provisions of the provincialization norm, section 4, section 3. Wherever they do not fit in, they are challenging.
Oh, okay. Then what should we do? In absence of the council, how to proceed? We'll admit them and then list for hearing in due course. What else?
Not.
You're ready, sir?
My lord, I have some item 23, 25, 28, my lord.
Hmm.
And in these petitions also, my lord, they challenge to a particular provision of the sections, my lord.
Yes.
That this section has, my lord, violates the right of the petitioner that we have been classified as a class of people that we cannot be provincialized, my lord. So those sections is under challenge, my lord. A detailed hearing is required, my lord.
So we are ready to do that. Still only 10:40.
My lord, my lord.
Why are you worried? We'll not stop you from
My
arguing.
lord.
Argue to your heart's content.
My lord, some senior councils are leading, my lord. So if we bypass those senior councils, my lord, may not be, my lord.
You don't bother. You argue your case. We'll give them the liberty to argue.
My lord.
Let them follow your lead. Otherwise, we'll admit the petitions and leave them for hearing in due course. That's the only way out then.
My lord. My lord, may I admit this? That's all.
All right, then, Mr. AG, we'll admit and
After
list
summer vacation.
after summer vacation. Yes. These writ petitions, this bunch of writ petitions involve challenge to the provisions of Assam so and so Provincialization Act 2017.
2007.
My lord.
17. The matters are pending for varying
Hearing
periods
approval,
between 5 to 1 year. Today also, comma, the matters have been listed after bunching all similar petitions, but none of the councils representing the petitioners are prepared to argue the matter, their respective cases in view of the peculiar facts noted above, and as some of the writ petitions are pending for admission since the year 2017/18, all the writ petitions are hereby admitted. The respondents are duly served. pleadings have been completed,
My lord.
list for hearing in due course.
My lord, immediately after the summer vacation.
Now there is no choice with you, sir. You had the choice to argue it today. Now it's left to the registry. Let them list, file early hearing applications then.
My lord. Oblige me.
We feel that learned Advocate General must have adjusted his other assignments
My lord.
so that these matters could be taken up.
My lord.
And we also got listed fewer cases because we thought that these cases will be argued. Now we are straight off coming into hearing category. What we'll do till 1:15? Let us know. Really bad, really bad. Absolutely.
Oblige me.
Item number 75.
Yes.
I speak, lordship.
Yes, please.
My lord, my last order, your lordship, granted time to file affidavit in opposition, lordship. Lord, that is not.
Lordship, I request some more time.
Why, madam?
Meantime, Lordship, I have requested the council to provide us the extra copies, but till date, nothing has been.
It was
provided.
soft, lordship, if lordship.
This way I am also. facing-
You didn't make any such request on that day. This is now a new excuse coming out
No,
for getting an adjournment. You could have called him up.
I have requested so many times, Lordship.
So many times it was soft, lordship.
All right, you could have given one more copy. All right.
Lordship,
Then Senior Competent Advocate M.S.M. Bhattacharya submits that she does not have available the copy of the writ petition and thus, the affidavit could not be filed. Counsel for the petition shall forthwith supply copy of the writ appeal to the learned government advocate who prays for and is granted 4 weeks further opportunity to file affidavit.
my lord. Date, what, my lord?
Date, after 4 weeks, fix a date. 26th, 29th May.
Oblige, lord.
Item number 76.
Yes.
Item 76, on behalf of the SC, we are filing the affidavit today. Kindly give us consent.
This is preventive detention matter.
Yes, lordship, this is preventive
We are filing
detention.
the affidavit. It has come.
Preventive detention, why the writ petitions are being entertained by SB? We fail to understand. Rupam, what is the position of rules? Can a habeas corpus petition be entertained by SB? Immediate, make a clarification today. They can't be entertained by single bench. This is the second case we are coming across. All right. The affidavits must have been filed in SB. This is the writ petition.
This is writ petition, lordship, writ petition criminal habeas
Oh,
corpus,
okay,
lordship.
okay.
Notice, lordship, and
So I'm under a misconception. Yes, Mr. Nath submits that he would be filing affidavit on behalf of
Respondent number 6.
respondent number 6. Who is the detaining authority?
Today, mother, there for commissioner also, I need 1 week time.
And you have to file these matters are required to be taken up urgently. He would be filing a reply affidavit on behalf of response numbers 2 to 7, all home department and police. 2 to 7 within
But 6 today I am filing and other 1 week time for the applicant.
within next 7 days.
By
Detention matters, you can't be so slack.
by
Every day counts. Union of India, affidavit not required. It's a detention of state government.
state government.
The affidavit on behalf of Union of India be also filed within next, by next date of listing. Re-notify on 10th May.
Highly obliged.
Yes. That's right. No, I thought that this was a writ appeal. That's why the confusion. That's right. That's right.
Item number 77.
May I please?
Yes.
Lord, we submitted that your lordship's judgment will cover this and your lordship's.
Yes, Mr. Chaudhary.
My instruction is that lordship, from first lordship, they are not here.
They are not,
They are not occupying the stocks.
they are not occupying this
No,
function.
no,
Can you file your affidavit then?
Yeah,
But this affidavit must have been filed in SB also. What is the status of your affidavit in SB before single bench? Did you take this
It was dismissed in limine.
limine? Then we need their pleadings then, sir.
Yeah, that's why.
Mr. Chaudhary, Deputy SGI, Mr. Chaudhary submits that as per instructions received by him, the case is not covered by the order passed in WA number 54/23, and that he needs time to file affidavit on behalf of the respondents.
Your lordship will maintain the status quo because their own board has given me lot status quo from.
Status quo as it exists today
Yes,
regarding
yes,
the petitioner shall be maintained till next date of listing.
yes.
Petitioner's license shall be maintained till
Yes.
next date of listing. Re-notify on, when do you want? How many? 3 weeks time, list after 3 weeks. Because if they are not having, the status quo would not make any difference.
So we have annex photographs also with the addition.
Very well, very well.
They're running it. And also
Yes.
the photograph of RPF trying to close and take the photograph.
We will take them first, yes. We'll take up the hearing matters after the fresh matters in supplementary. Yes,
Item number 95 and 96 of supplementary list.
In 96, item number 95, we are required to file this affidavit. I'll be getting the instruction today. They have prepared the instruction, they told me, I'll by today I'll get, kindly give us some time, I'll be putting in a record by filing.
Mr. Nath, then Government Counsel, Mr. Nath submits that he has received instructions.
No, I talked to the secretary, he's sending the instruction today.
He needs some more time to respond to the observations. File the detailed response in terms of the direction given by this court on 31st March 2023. Re-notify on date 16th May. 16th May. The other one is, what is the suo moto?
These two methods are connected,
What is this about? Do you have any idea?
but as regard construction of vulnerable witness deposition center.
Hmm.
because prosecution taken up, and centers are being in some of the district where it is functioning, and in respect of others, lordship has called for a report from the state legal services authority. They have given a report.
This is basically in furtherance of Sampurna Berwa.
True.
This PIL was registered as a consequence of Sampurna Berwa's
Yes.
directions.
Lot.
So, all right, we'll take it up together on that next day only.
Because the steps taken will be in the,
Okay.
As per the report, how many districts have already been, the vulnerable witness centers have been
in 16 it's functioning.
16?
And some temporary arrangements are also under construction in other districts. But the report from the state legal service authority is called for.
It has been prepared, but DNMO copy.
This
I'm
petition has
yet to
come up
get the copy of the report because the committee has visited the jail. But I'm yet to get the copy.
Copy of the reports. The reports have been filed in which case?
In Tomato PI.
So moto, there is
That is 1/19.
the factual report filed in the suo motu, copy of the factual report filed in the suo motu petition shall be provided to learned amicus curiae Mr. Das,
Copy may be given to us.
as well as the Government Counsel Mr. Nath within next 7 days. Re-notify on 16th May. There was one petition by the name of Sampurna Berua also.
Milord, in that case, your lordship, on the last occasion, counsel from Delhi, he appeared, and Milord, my friend is appearing.
The lordship, that is the case wherein my learned friend sought for time.
Exactly.
We are required to file a detailed affidavit.
When is that matter coming up? We'll tag the bunch them.
It is tagged, your lordship. That is item number 95.
95 is Bachpan Bachao.
Bachpan
There is
Bachao.
one petition by the name of Sampurna Berua also.
She is the petition number 2 in
In this
Bachpan.
very case.
In this very case.
Okay, okay, very well.
In fact, the report was called for from the state in this matter on the last occasion, Sampurna Behura.
Yes. So he is yet to file it.
That detailed affidavit we are-
Deeply obliged.
Item number 97 for fresh admission, which state?
Made please, your lordships. Well, petitioner herein is aggrieved, by order dated 24 2023, passed in the WPC number 146, whereby the runner single judge was not inclined to grant the interim prayer by staying the of a NIT Here, initially what happened, the appellant he was qualified in 4 wards in terms of NIT dated 21/5/2022. Thereafter, in all those 4 words, he was allotted the letter of acceptance. After issuing the letter of acceptance, the petitioner had initiated some words, particularly in this package, AS 17 to 60. He had already completed 20%, 10% of words, and all missionaries are installed there. What happened, after issuing the letter of acceptance, the chief engineer has demanded some additional security, performance security, and accordingly, in all this package, one of those 4 packages, including this present package, challenge that demand of additional performance security, the appellant earlier filed 4 petitions. In those 4 petitions, while this matters were came before this one of single judge, the single judge rejected that right order, that order, kindly find your lordship at page 56.
Challenge was given to the demand of additional performance security.
Kindly see page 57, I am reading last 3rd paragraph from the bottom, balancing the equities, it is directed that till the next date fixed, that is 13/3/2023, no coercive action of any measure connected with the additional performance security be taken against the petitioner. This order was passed, on 24/2/2023. Although, the court had directed, in the interim, no coercive action should be taken, the CPG, what he had done, he had issued NIT, during the pendency of this order.
NIT.
NIT,
So how is that action restrained by this interim order? Fresh NIT has been issued.
Here, this court has directed that till the next date fixed 13/3, 13/3/2023, till, no coercive action of any measure.
13/3.
Yes,
You are reading order dated 24.
Yes, yes,
So,
and there is a interim pyramid, interim order
yes.
there,
Okay.
till next date fixed.
So have they cancelled your contract? What have they done?
No, they had not cancelled, but they had issued, yes, in fact, they had cancelled.
Where is
Issued
that cancellation?
NIT,
Where is that cancellation order?
kindly see page 58,
58. Okay. Judgment issued based on this should be honored by either side.
Therefore, another development, what happened, he had subsequently, he had filed another definition, that the additional performance security may be adjusted from some other amount due to payable to the petitioner. That was not considered, subsequently he had filed another petition before the honorable court. This order will find, at page 65. 65. and relevant portion your lordship will find at page 67, my lord.
Yes,
May I read, my lord, that
sure.
my lord. I am reading my lord, third paragraph, my lord. The petitioner had raised a grievance on the issue of requirement of additional performance security on the works on certain grounds, which however have not been accepted by the court. Thereafter, though there have been other developments in this case, the petitioner has expressed his willingness to make the said deposit, which has been rejected only on the ground that the work in question has been retendered. Though the rejection of the authority per se does not appear to be wholly unreasonable, as the work has already been put up to retender. Considering the peculiar facts and circumstances, this court is in exercise of its equitable jurisdiction as an exceptional case, directs the authorities in question, namely the chief engineer, Public Works Department, Border Roads, to reconsider the offer made by the petitioner. Therefore, petitioner had all the, I'm reading the remaining part, the offer made by the petitioner regarding his willingness to pay the entire amount of additional performance security only for the work in question, namely yes 17 to 60. This is the current package, I'm saying before your lordship.
Right.
The learned counsel for the petitioner has considered that the offer made is only in respect of the said work. For the other three works, he is not in a position to make such offer. My lord, here, my lord, petitioner has already given up about the other three works. My lord. He has confined only with this work, my lord.
All right. Then
Then, my lord, what happened, my lord? They are, or since they are going to retain, already issued a retender, my lord. So, my lord,
what is the speaking order in pursuance of this judgment of learned single bench?
speaking order, my lord, kindly see,
It's at page number 69.
my lord.
Read.
My lord,
The department has analyzed
my lord.
the subsequent
department
sequence of
has
developments.
My lord.
Yes.
The department has analyzed the sequence of development of the issue and found the following facts. The deponent has so far performed and acted as per the provision of bidding documents. After the bidder's plea challenging additional performance security was dismissed by the Honorable Court, he was given a time period to submit performance security and additional performance security from 16 to 2023 to 25 to 2023. File letter number so and so dated 16 to 2023. My lord, they are saying that this is their letter, my lord. But the court has already extended my time to, my lord, the order, my lord, 2023, my lord. That earlier order, my lord.
No coercive
My lord.
measures.
13/3/2023, my lord.
Gentlemen, but the 13.3 is at page number
My lord, 57, my lord.
57. Yes. 57.
My lord.
Mm.
They are not referring this, my lord. Revenue part, my lord. On failure of the bidder to submit PS and additional PS, the bidder bid security was forfeited on 28 to
Mr. AG, AG sir, you are appearing.
I am appealing. Okay.
The order of 24th February says no coercive process. Quasi performance security and additional. And your speaking order says forfeiture was done on 28/2. How could it have been done?
Lordship, I have not received a copy of this petition. So
Give a copy.
yeah, I have come tomorrow, Lordship will clarify.
Oh, yes.
everything.
Oh, yes. Oh, yes. Definitely. Copy
But
of
there
the,
was no violation of any court order from our side.
apparently there seems to be a violation.
Uh,
You just have a look at it. The stay order is of 24th February.
Lordship.
You were represented, and despite that, you have forfeited the performance security on 28th February.
It was stopped, I think. My friend appeared in that case.
But your speaking order says that it was forfeited, and on that count only the re-tender has been done. You just have a look at it.
Thereafter, he came before the division bench. Lordship was also pleased to dismiss. All these things are not dismissed.
that is earlier.
It's okay. But the issue is when there is a stay directing you not to take any coercive action, then how could you
We'll
forfeit
verify.
it? Tomorrow, copy of the writ appeal and the next and the documents, complete paper book be provided to the Advocate General who appears on behalf of the respondents forthwith.
Except
This-
the Union of India is also there.
Respondent number so and so, Union of India, madam, appears. List tomorrow,
I love it.
28th April.
Item number 98 and 99.
Name of an Advocate General challenge for the reflector in the list. Yes.
my lord, in 98, my lord, the respondent one, my lord, for the first time has filed one affidavit, my lord, stating that, my lord, the Hill Areas Department Deputy Secretary is the necessary party here who is to provide the fund. That affidavit was earlier not in the writ petition. So a new fact was brought, my lord, from where we came to know, my lord, that direction has to be issued to that authority also for the purpose of, my lord, giving the relief. I pray if your lordship will allow me, I may be allowed to implead the party, my lord. It is in paragraph number 2, my lord, page 105 of the affidavit.
All right.
Therefore, the issue of releasing of fund to the concerned executive engineer should be made by the Deputy Secretary to the Government of Assam. Hill Areas
Council,
Department.
the appellant submits that in view of amendments made at para number 2 of the affidavit in opposition, he is required to implead the Deputy Secretary to the Government of Assam, Hill Areas Development, Dispur, as a party respondent in this petition. He is allowed to move the requisite application list up upon the application being moved, the matter be listed for orders immediately thereafter.
Your lordship. Item number 99 is not clubbed with this case, lordship. This is a case of the government of Sikkim. The
Item
other
number
one
99.
of Assam.
All right.
Lordship, this is a urgent matter, lordship, and we are for the respondents. I am led.
Is there any order of clubbing? No.
No, lordship.
Why is with, why this is
Absolutely disjointed.
shown as with in the cause list? All right, yes,
I'm
please.
the respondents, lordship. I'm led by Mr. K.N. Chaudhary, senior advocate. It came up as a supplementary matter. I could not.
What do you want? What do you want?
It is listed on Thursday, lordship, the 4th for hearing, admission hearing.
As paid by land council and so and so, appearing for the respondent, list on, you want it
4th, lordship.
on 4th May. For admission.
Item number 101.
May it please, your lordship. Well, this is a contractual matter where there is an interim stay. The second time, your lordship had said it to the government because I was given the allotment and the respondent challenged it on the ground that I could not have been given. For the second time, for an objective assessment, it went to the government and government has passed a detailed speaking order. Considering my performance, I was being allowed.
Nair represents
for the government to.
Supporting him.
Yes.
We know that we recollect that. So Mr. Nair is supposed to be here
Yes, madam.
for the private respondent.
One on the last occasion also,
Has he been briefed or not?
Your lordship, opinions on that.
So you want to pass over for the time being or what? Pass over.
Item number 78 of daily list.
Yes.
Yes, your lordship, as per the last order, the Union of India was required to file an affidavit clarifying the discrepancies in the population census.
I have received the comments, I have prepared the affidavit and sent. The problem has arisen because the affidavit to be sworn, they are not parties in the hearing. And
You can't go on technicalities in PILs.
that can be. However, lordship, they are seeking 2 weeks time. I have prepared it and have sent it to them.
You need to change now. Now things are required to be done by digital signatures.
What I can state is.
Mr. Chaudhary, we have given you too much of
I-
an adjustment. Now your filings were required to be by e-filing mode long back from 1st of January,
It has to be, Lordship, first.
digital signature,
Yes.
and immediately push it into the system. The filing is done. So
E-filing, Lordship, I am doing it here.
you are doing it.
I'm doing.
How many e-filings have you done?
From my side, Lordship, at least 3-4 affidavits.
Okay, very well.
And here,
Let's give
Lordship,
them
I-
one more opportunity. He says that he has forwarded the affidavit to the authorities in Delhi. He is waiting for the affidavit to be signed and presented here. Mr. Deputy SJ, Mr. Chaudhary submits that the affidavit has been forwarded to the authorized officer and shall be filed shortly hereinafter. Affidavit in terms of the order dated so and so, 23rd February 2023. How much time would you need?
Lordship, they asked for 2 weeks.
So almost 2 months now, more than 2 months.
But the-
Last opportunity is being granted for this purpose. Re-notify on 23rd May. And then what is the second matter? What is the IE about?
Your lordship, IE was actually nothing. It was an additional prayer, but simultaneously by this honorable court order, we have added those prayer in the main petition and amended.
So we can dispose of the IE? On
Yes,
the
yes.
statement of petitioner's counsel, the interlocutory application, the petitioner appearing in person, comma, the interlocutory application is disposed of because the amendments made therein have already been incorporated in the main writ petition.
Obliged, your lordship.
The number 79.
I may be permitted to leave, your lordship.
Yes, yes, please. Sure. Yes.
Lordship, I've had a word with my learned friend. If this matter may be fixed for hearing on the 4th of May, Lordship.
Oh, yeah, is there any difficulties? Today is not an
on my part,
auspicious
on the request
day.
of my learned friend, my lord.
Matters listed in hearing category. What instructions are required now?
I understand your lordship.
Pleadings are complete. The file is there with us. It's to be decided on whatever material is there on record. It's
Lordship,
very easy for you to stand up and say so.
My lord, I
Then what should we do of the hearing list? The members of the bar, they implored us when we were called to the bar that hearing matters are not being taken up. And when we try to do it, every matter for whichever is listed, there is a request, need time to complete instructions. See the sad state of affairs. You are for the state of Mizoram. So and so appearing for the state of Mizoram. Respondent state of Mizoram.
If the
Yes.
item may kindly come up on the 4th of May, Lordship.
We can't say it's not possible on 4th of May.
Lordship, this matter has been pending for so long. and-
All right, argue. We don't
Yes, sir, yes, sir.
accept his request. You argue. Accepting his request for adjournment is not automatic. Simply because he has asked for it. You argue.
Lordship, if my learned friend has asked for time as well, so Lordship, if
So
your
you are
Lordship
also
may
not
kindly
prepared.
give us the 4th of May.
You are also not prepared. Say so. Admit that
Lordship.
fact. Re-notify on 23rd May. We have our own schedule of cases. So we just can't go on adding to the hearing list. Just every 4th day. It's not possible. Yes.
Obliged, Lordship.
Item number 82.
I appear for the universal.
Feel that the advocate was there in the first matter. Same counsel. All right, then none present, dismissed for want of prosecution. It's really too much. He was here in the previous case. And he has left the board and gone. Is it right? Mr. L. Silo.
I think it's. I apologize, Lordship.
Yes.
Lordship, the reason we have filed this writ appeal is that the respondents have deliberately refused to grant us the financial upgradation under the MACPS, Modified Assured Career Progression Scheme, Lordship, as well as the financial rectification, which was directed by the UGC, Lordship, with effect from 1st January 2006, Lordship. Lordship, we are employees of Patsunga University College, Lordship, and currently working as lab assistant. Prior to this, Lordship, we have been appointed at the initial stage, we have been appointed as junior lab assistant, Lordship, recruited as junior lab assistant, which was a post which was inherited from the erstwhile NEHU, Lordship, before Mizoram University came into existence, Lordship, before it was established, Lordship. And after MZU was established, Lordship, Patsunga University College came under MZU as a constituent college, Lordship. Lordship, at the time of recruitment, our grade pay was fixed at 1,900. Thereafter, Lordship, in the year 2010, the governing body of MZU, of the respondent authority, had an executive executive council of the MZU had a meeting, and wherein it was decided that the post of junior lab assistant, which was inherited from NEHU, since being a redundant post, be absorbed as a lab assistant, Lordship, which is the only post which is in existence under MZU, Lordship. And Lordship, what I want to make clear before this court is that these two posts of junior lab assistant and lab assistant are one and the same, Lordship. Same educational qualification, same responsibility, Lordship. Lordship, at this point, I would like to make it clear that all the appellants, all of us, we have completed more than 10 years of service in the same post, which is a stagnant post, Lordship. There is no avenue for promotion in this post, Lordship.
Okay.
Lordship, at the time of our redesignation, as per the 26th meeting of the Executive Council, Lordship, if your Lordship may kindly come to page number 94, Lordship.
Can we first find out the reason why you have not been given the benefit of the MACP? Can you please elaborate on that from the judgment?
Certainly, Lordship. Lordship, the reason is that after being redesignated as lab assistant,
Earlier service was not counted. That
was
is the
not
reason.
counted, Lordship.
Then,
The reason is that the reason is given in if your Lordship may kindly give me one moment, Lordship. If your Lordship may kindly give me one moment.
Sure.
Page number 100, Lordship.
take your time.
If your Lordship may kindly come to page number 100.
Yes.
Lordship, this is the corrigendum dated 11th May 2016, which has
Whereby
been
the
issued by the
benefits
respondent
Earlier
authority.
given to you were withdrawn.
Lordship.
Benefits given to you were withdrawn.
Yeah, Lordship.
Yes.
We have been granted, we have initially, after being redesignated, we have also been granted this first MACP financial upgradation.
Okay.
And thereafter, which is in line with the decision of the Executive Council of MZU, Lordship. And thereafter, orders were passed, notifications were made, and we were granted our financial upgradation, our first financial upgradation under the MACPS, Lordship. However, after all of this, there was a change of heart on the part of the respondent authority, Lordship. And this corrigendum, page number 100, dated 11th May 2016 was issued, Lordship. May I read it out, Lordship?
Yes, yes.
On scrutiny of notification dated so-and-so, dated 16th November 2011, order so-and-so dated 30th January 2015, and order so-and-so dated 21st December 2015, with regard to grant of financial upgradation on account of MACP scheme. Discrepancies, inconsistencies appeared in respect of the two lab assistants of Patsuma University College, viz. Sri Adi Lalthansanga and Sri Laramthara Patsuau, which was inadvertently mistaken. Hence, the pay of the two incumbents is amended as per statement enclosed herewith. This supersedes the above mentioned notification orders in respect of the said incumbents. Lordship.
Okay.
This is the corrigendum which was issued by the respondent, Lordship. Now, Lordship, if your Lordship may kindly come to page number 95, Lordship. 94 and 95, Lordship.
Yes.
Lordship, this is the 26th meeting. This is the meeting minutes of the 26th meeting of the Executive Council, Lordship. And the effective portion is in page number 95, Lordship. If I may read it out, Lordship.
Yes, yes.
The second paragraph, Lordship. Moreover, the pay band is also the same. There is a difference of ₹100 in grade pay. It is therefore felt necessary to maintain uniform hierarchical structure in lab service under MZU. Attach same grade pay for the post which required the same educational qualification, same nature of duties, and same responsibilities. Avoid multiplicity of grade in lab service, which is likely to cause promotional and ACP problem for the effective employee, Lordship. Lordship, the ethos and the spirit of this of the Executive Council and the intention of the Executive Council is clearly highlighted in this meeting minute, Lordship. It is to attach same grade pay, Lordship. Now the respondent authorities have claimed that due to our redesignation, wherein initially at the time of our recruitment, our grade pay was 1900 under PUC, because this post under PUC was inherited from Nehu. At that time, Lordship, the entry grade pay was 1900, Lordship. But under MZU, the entry grade pay is ₹2000, Lordship. Now, in order to fix this anomaly, and in order to attach same grade pay in the same post under MZU and under PUC, the Executive Council has decided to attach same grade pay while redesignating the post of junior lab assistant as lab assistant, Lordship. And also in point number 3, it clearly states that avoid multiplicity of grade in lab service, which is likely to cause promotional and ACP problem for the effective employee, Lordship. Now, this point has also stated that has also been made in order to protect the service of the appellants, Lordship, so as they do not meet any they avoid any problem in their MACPS, Lordship, in their financial upgradation, in their benefits, Lordship. Now, the respondent authorities what they have claimed is that, Lordship, at the time of our redesignation, our grade pay has been fixed from 1900 to align it with the post of lab assistant in MZU as ₹2000. Now the respondents have claimed that this redesignation is a promotion along with financial upgradation from 1900 to 2000. Now this is the main reason that the respondent authorities, even after giving us the financial upgradation as per the MACPS, have issued the corrigendum and retracted their own prior notifications and orders giving us the financial upgradation, Lordship. Apart from this, Lordship, if I may take your Lordship to page yes. Page number 88, Lordship.
Oh. Yes. Yes.
Page number 88, Lordship. Now, this is the direction issued by the UGC, University Grants Commission, to all central universities, Lordship, regarding the rectification of core pay scale of the post of lab assistants. If I may read it out, Lordship. References were received from Delhi University and DUC-KU on certain issues, including rectification of the core pay scale of lab assistant from 3,200 to 4,000 pre-revised to 4,000 to 6,000 pre-revised. A committee was constituted by MHRD to look into these issues. The matter was considered by MHRD, Government of India, and it has been decided to rectify the core pay scale of lab assistant of University of Delhi to rupees 4,000 to 6,000 instead of rupees 3,200 to 4,900. Now these amounts translate to rupees 2,000 rate pay to rupees 2,400 rate pay, Lordship. Accordingly, the undersigned is directed to convey the approval of UGC to rectify the core pay scale of lab assistant to all central universities and UGC maintained deemed to be universities from rupees 3,200 to 4,000 to 4,000 to 6,000 with effect from 1st January 2006, Lordship. Now, after this direction was issued by the UGC, Lordship, the respondent authority have also issued a notification, Lordship. Which is given in page number 97, Lordship.
Yes. 97.
Page number 97, Lordship. If I may, Lordship.
Yes.
Consequent to the UGC's letter so-and-so dated 4th April 2015, the Vice Chancellor, Mizoram University, is pleased to implement the rectification of the core pay scale of lab assistant under Mizoram University and Patsunga University College from rupees 3,200 to 4,000, pre-revised to rupees 4,000 to 6,000, pre-revised with effect from 1st January 2006, revised pay, that is 2,000 to 2,400 of the 6th CPC recommendation. Clarification of pay in respect of incumbents who were appointed against the post of field research assistants is being sought for to UGC. Hence, their pay will be determined depending on the clarification of UGC. Now, Lordship, as per this notification, we have also been granted this rectification of core pay scale from grade pay of rupees 2,000 to 2,400 with effect from 1/1/2006 initially, Lordship. But what happened is that after all of this corrigendum, the said corrigendum was issued by the respondent authority again, whereby they have retracted all their earlier notifications and refused us to grant this financial upgradation under the MACPS, as well as this rectification of core pay scale as per the direction of the UGC, Lordship. Now, Lordship, while all of this is happening, if I may kindly take your Lordship to page number 177, Lordship. Lordship, this is an additional affidavit which we have filed, and through this affidavit, we have brought to light certain discriminatory actions of the respondent authorities against us, Lordship, which is given in annexure number 3 of this page number 192, Lordship. Lordship, what has happened is that there is a post of field research assistants. Now, Lordship, what the respondent authorities have done is that the rectification of core pay scale as per the UGC direction, which was meant for the post of lab assistant, has been extended to the post of field assistants who are working directly under Mizoram University, Lordship. And they have been granted the rectification, core pay scale rectification of rupees 2,000 to 2,400 rate pay with effect from 1st January 2006, Lordship. And in specifically serial number 10 and 11, Lordship. These of page number 192, Lordship. 192. Serial number 10 and 11. Laltan Thangaralte and R. Laltan Hima. Now, Lordship, these two employees of Mizoram University, it shows from this order, this is the financial upgradation under MACPS, Lordship. This is an order which has been passed in relation to the financial upgradation under MACPS. Now, it can be seen that they have received their first MACPS, in the year 2015, Lordship. Effective dates are 21st November 2015 and 23rd November 2015, Lordship. Now, this is their first MACP, Lordship. Now, this shows that these two persons have been recruited in the year 2005, Lordship. And their entry grade pay was rupees 2000, Lordship. And after being given this rectified core pay scale from rupees 2000 to 2400, now their first MACPS, their first financial upgradation under MACPS has been upgraded from rupees 2400 to 2800, Lordship. Now the UGC, Lordship, has not given a direction saying that the rectified core pay scale should be given to any other post except for lab assistant. In their letter, it has been clearly written that the post which has to be given this rectified core pay scale is that the post of lab assistant, Lordship. Now, the respondent authorities, in their discretion, have extended this benefit to this post, to this other post, while rejecting us the same, and also giving them their first financial upgradation from rupees 2400 to rupees 2800, Lordship, while denying the same to us, Lordship.
Okay, that's it. You can
Lordship,
follow.
that's mainly for it, Lordship.
You don't want to criticize the judgment of the single bench?
Lordship, I will come to that later, but Lordship, if Lordship would kindly give me a moment, Lordship. Now, Lordship, the single judge, after hearing the matter, has concluded that since the appellants have not been serving in the same post, it appears that the single judge has misinterpreted the decision of the Executive Council in redesignating the appellants from the post of junior lab assistant to lab assistant.
Read the finding.
Lordship, if I may, Lordship.
Yes.
Page number 28, Lordship.
Page 28
Page number 28, Lordship.
of what?
Page of my read appeal, Lordship.
Which para of the judgment?
Page number 20, I apologize, Lordship, page number 27, Lordship. This is the conclusion and decision of the learned single judge, Lordship. That the learned single judge, after hearing the parties, dismissed the writ petition number 96 of 2019 by the impugned judgment and order dated 9/9/2021. That the operative portion of the impugned judgment and order dated 9/9/2021 run as follows. From the facts projected herein above, the claim of the petitioners is that they should be given upgradation of their pay in terms of the MACPS on the completion of 10 years of regular service in the grade. On the other hand, the case of the respondents is that since they were redesignated from junior lab assistant with effect from 5/10/2010 only, vide order dated 29/4/2011, they will be getting their first upgradation of pay in terms of the MACPS on completion of 10 years of regular service with effect from 5/10/2010. Facts not disputed are that the petitioner number 1 was appointed as junior lab assistant on officiating basis in the year 1995, and he was regularized to the post on 1st June 2004. The petitioner number 2 was appointed as senior lab assistant on regular basis with effect from 10/6/1997, vide order dated 7/7/1997. As for the petitioner numbers 3, 4, and 5, they were all appointed on regular basis as junior lab assistant on 16/4/2008. The effective date of joining of the petitioner number 3 is 7/4/2008, and for the petitioner numbers 4 and 5, the effective date is 10/4/2008. While the petitioners were serving as such, pursuant to the decision taken by the Executive Council in its 26th meeting on 5/10/2010, it was decided that the post of junior lab assistant lab assistant in the scale of PB1 rupees 5,200 to 20,200 with grade pay of rupees 2,000 with effect from 5/10/2010. Be it stated herein that the grade pay of junior lab assistant prior to the redesignation was rupees 1,900. Consequently, the UGC conveyed its approval to rectify the core pay scale of lab assistant to all central universities and UGC maintained deemed to be universities from rupees 3,200, 4,000 to 4,000, 6,000 with effect from 1/1/2006. Vide communication dated March 2015. Pursuant to the said communication, the core pay scale of lab assistant under MZU and PUC were rectified from rupees 3,200, 4,000 to 4,000, 6,000 with effect from 1/1/2006. That is grade pay of rupees 2,400 of the 6 CPC recommendation. Vide notification dated 29/5/2015. Therefore, the grade pay of lab assistant was rectified, enhanced from rupees 2,000 to rupees 2,400. Under the MACPS notified Vide OM dated 19/5/2009 by the Government of India in the Ministry of Personnel, Public Grievance and Pensions, Department of Personnel Training, 3 financial upgradation is permissible at the intervals of 10, 20, and 30 years of continuous regular service. The MACPS has been made operational with effect from 1/9/2008. The MACPS further provides that the financial upgradation will be admissible whenever a person has spent 10 years continuously in the same grade pay, in the same grade. In the present case, as may be noticed, the grade pay of lab assistant was enhanced to rupees 2,000 from rupees 1,900 with effect from 5/10/2010 when the post was redesignated as lab assistant. Therefore, with the rectification of the grade pay scale of lab assistant as approved by the UGC, the grade pay was further rectified, enhanced to rupees 2,400 from rupees 2,000. As already noticed herein above, financial upgradation under the MACPS will be admissible whenever a person has spent 10 years continuously in the same grade pay. The petitioners in the present case undisputedly did not remain in the same grade pay of rupees 1,900 since their appointment to the post on regular basis. Therefore, they will be entitled to their first upgradation of pay under MACPS on completion of 10 years of regular service in the grade counting from 5/10/2010 only. Having come to the above conclusion, the authorities relied upon the counsel by the counsel for the respondents need not be discussed. In the result, I do not find any merit in the writ petition and the same is dismissed, Lordship. Now, Lordship, if I may, what the learned single judge have failed to appreciate in this judgment is that the redesignation, the intention of the Executive Council of MZU of the respondent is clearly reflected in the 26th meeting of the Executive Council, Lordship, which is to attach same grade pay between the 2 posts, which are one and the same under PUC and under MZU, Lordship, and to avoid multiplicity in the grade pay, as well as not to cause any promotional problem in the MACPS in the benefits under the MACPS scheme, Lordship. Now, the respondent authorities through the Executive Council have merely redesignated the appellants from the post of junior lab assistant to lab assistant while attaching the grade pay which is already in existence under the MZU, under the Mizoram University, Lordship, which is rupees 2,000, the entry grade pay, Lordship. Now, Lordship, the learned single judge has also stated that the grade pay, when we were redesignated, when the grade pay was attached as per the entry grade pay of the lab assistants under MZU, the learned single judge came to the conclusion that we have received financial upgradation.
Yes, all right, we understand.
Lordship.
Okay, yes, please.
Not the entire case.
How is it a financial upgradation, sir? It's a redesignation of the post. There's a difference of 100 rupees being caused. Don't do the redesignation, all right, withdraw that. Will they get the MACPS on 10 years or not?
Yeah.
So this is a redesignation. How it is a financial upgradation?
We are not merely on the redesignation.
Then
in 2015,
yes,
they got a upgradation. But
how?
If your lordship will just allow me to place the rules.
Yes.
The rules, that is what I was expecting my learned to place. Your lordship will have a look at the rule. This is Central Civil Services Revised Pay Rules.
CCS revised pay rules.
For this case, in my humble understanding, only two.
You say that this enhancement of 2400, 2000 to 2400, that is an
If your lordship will
upgradation.
kindly first come to rule 4, scale of pay of post.
These are classification, control and appeal. Pay scale rules.
The Central Civil Services revised pay rules 2008. In this book, it will be at page 2074.
2074. Volume 2.
Volume 3.
The concept of MACP is that the person who has served for 10 years, because the post is stagnant, there is no avenue for promotion. So the pay scale of the next promotional post is provided.
Precisely.
In this case, whether this addition of 100 rupees or even say this enhancement from 2000 to 2400, would it take the employee to the next promotional post?
Yes, that is what I was about to.
Let's see.
That is exactly what I was about.
If there's an upgradation to the next financial upgradation equivalent to that, there is an automatic financial upgrade 2074. No, all right. Yes.
If your lordship kindly turns the page, your lordship will find rule 4.
Rule 4. Yes.
Scale of pay of post. The pay band and grade pay of the pay scale as applicable of every post grade specified in column 2 of the first schedule shall be as specified against it in columns 5 and 6 thereof. Now your lordship kindly turns to the schedule, which your lordship will find at page 2086, the first schedule.
Yes.
Now, if your lordship kindly comes to serial number 6, against the post S5, the grade pay, corresponding grade pay revised is on the extreme right hand column is 1900.
Yes.
Next promotional post S6 is 2000 and S7 is 2400. So the scheme, if your lordship has a look at the scheme, what it says that if you are languishing in the same grade pay, only then after every 10 years you will be entitled to the next higher.
Upgradation, yes.
So here, in whatever manner be it, they have received this upgradation in grade pay. So that being so, they are not entitled. If your lordship kindly has a look at the scheme now.
Yes.
The lordship will find the scheme at page 80.
Just.
It speaks about a lot of things, but I won't trouble your lordship with the entire document. Just the relevant portion I'll point out. Page 80, if your lordship straight away comes to para 2 there.
Eight zero. Yes.
That is annexure 3 to the memo.
Yes.
Para 2. The government has considered the recommendations of the 6th Central Pay Commission for introduction of MACP and has accepted the same with further modification to grant 3 financial upgradations under the MACP at intervals of 10, 20, and 30 years of continuous regular service. Be known as Modified Assured Career Progression Scheme for the central government civilian employees. This scheme is in supersession of previous ACP scheme and clarifications issued thereunder and shall be applicable to all regularly appointed Group A, B, and C central government civilian employees, except officers of the organized Group A service. The status of Group B employees would cease on their completion of prescribed training as recommended by the 6th Central Pay Commission and would be treated as Group C employees. Casual employees, including those granted temporary status and employees appointed in the government only on ad hoc or contract basis, shall not qualify for the benefits under the aforesaid scheme. The details of the MACP scheme and conditions for grant of the financial upgradation under the scheme are given in Annexure 1. This Annexure 1, your lordship will find at page 83.
Yes.
Page 83.
Mm.
And the very first paragraph makes the entitlement very clear.
Yes.
There shall be 3 financial upgradation under the MACP counted from the direct entry grade on completion of 10, 20, and 30 years service respectively. Financial upgradation under the scheme will be admissible whenever a person has spent 10 years continuously in the same grade pay. So here is not a case that they have been languishing in the same grade pay for 10 years.
Let's come back to your schedule one. Schedule 1. Schedule 1, column 3, name of pay band scale. Pay band 1, pay band 1, pay band 1.
True.
For S456. How is it an upgradation?
Well, that is what it says. The upgradation is qua the grade pay. Here, although it is in the same grade, the posts are higher.
Posts are higher. So the your financial implication would be 0. Merely because the pay band remains the same.
Pay band remains the same.
So how does it have a financial implication?
Because of the grade pay.
Would it define into a financial benefit because the person has been placed from S5 to S6? Would it go on to provide him the financial benefit?
That is where the grade pay comes to.
The pay band doesn't change.
Pay band doesn't.
Okay.
So it is under this entire, whatever is the entitlement is under the scheme. And as has rightly fallen from your lordships, the whole idea is to, since they are stagnating, on completion of 10 years, 20 years, and 30 years, you will get this financial upgradation so far as the grade pay is. And therefore, the learned single judge at para 10 has held that in whatever manner be it, you have received
the upgradation.
1900 to 2000,
And 2000 to 2400.
400. Therefore, we got now.
Yes. Yes. Anything else to say?
Yes, lordship.
Have you seen the schedule? Have you seen the schedule under the rules?
Lordship, lordship, that may be the case as per the schedule, but lordship, if I may kindly, lordship, if I may.
So are we to ignore the schedule, sir?
Lordship.
Scheme says upgradation from one grade pay to the next grade pay.
Lordship.
That you already been given 2, not only 1.
Lordship, we have
1900 to 2000, 2000 to 2400.
Lordship, what we have been granted, what we have been given is not a financial upgradation, lordship.
Read the schedule, sir. That is what
lordship,
you're saying.
If I may, lordship. Lordship, at the time of entry, our grade pay was 1900. Because only because this post under Patsuma University College was the one which was inherited from Nehu. At that time, before MZU was not established yet.
That you already said, sir, you need not
lordship.
repeat yourself.
So, lordship, if after Mizoram University was established, the post of lab assistant under MZU received an entry grade pay of rupees 2000, lordship.
Yes.
Now, thereafter, the executive council
So that is the
decided
next,
to give us this.
next promotional post as per this schedule. S5 to S6, you have gone into S5 to S6.
Lordship,
And that would, yes, definitely translate into financial benefits also. Because the present scale has been changed. 3050 to 3950, that was as for S5, and that translates into 3200 to 4900 for S6. So that financial upgradation is there. Read the schedule. It will be clear to you. Do you have the schedule with you? Read. Read the schedule, please. Read S5 and S6, present scale. 1900 is on the right side. So you have been upgraded from 1900 to 2000. and see the difference in the scale, pay scale for S5 and S6. That will make it clear.
Lordship.
Yes.
Lordship, yes, as per the rules, this is financial upgradation.
Yes.
Lordship, however, what has to be considered, the fact that has to be considered is that had we been recruited under Mizoram University, our entry grade pay should have been rupees 2,000, Lordship. Now, Lordship, thereafter, this rectification of core pay scale under UGC is not a financial upgradation, rather a rectification of core pay scale, Lordship, which has been granted to all lab assistants, not just lab assistants
So
under
we are
Patsuma
not,
University
for the present,
College.
we are not considering taking into account that change from 2,000 to 200, 2,400. Let us ignore it for the moment. But
Lordship.
that 1,900 to 2,000, that is an upgradation as per the rules by
Lord-
itself.
Lordship, the Executive Council of Mizoram University have themselves clearly admitted in their meeting minutes of the 26th meeting.
That is an ignorance of the rules.
Lordship, they have clearly stated that this redesignation, the purpose of this redesignation is to attach same grade pay, Lordship.
Understood, sir, but that causes you to rise up in scale. So that is what the purpose of MACPS is. Okay, we'll consider. Thank you. All right, dismissed. Dismissed.
Item number 83.
Send this book inside. Yes.
New function, my lord. And I have to file an deputy in opposition in which case, my lord, they file after filing of the case.
In the
Which case, I civil, my lord, case 02.
3802.
I have to file, my lord,
3802 IA.
Yes.
You want to file an affidavit in that IA?
Yes.
What is the prayer in the IA?
My lord, they have taken another down case from. my-
Additional ground.
Yes.
All right. And counsel representing the respondent submits that certain additional grounds have been raised in interlocutory application number so and so, and he needs time to file an affidavit in opposition in the said IA. He prays for and is granted 4 weeks time to do the needful. List after 4 weeks.
Item number 84.
May it please your lordship, my lord.
Yes.
My lord, here, the my lord, appellant, my lord, there was a constable, my lord, in CRPF. He was, my lord, absent from duty for a period of, my lord, 347 days, my lord. Initially, he was granted leave, my lord, for medical treatment of his injury. He received one certain head injury, my lord. And my lord, the period of leave was, my lord, 6/1/2010 to 4/2/2010, my lord. Page 42 of the appeal, my lord. My lord, after that leave, my lord, he could not recover. He even admitted for treatment before the, my lord, Tezpur mental my lord, hospital also, my lord. And ultimately the authority found, the medical authority found he was not suffering from psychiatry. My lord, now behind the back of the petition, the inquiry was conducted. My lord, lordship may kindly directly see the inquiry. Or before that, my lord, article of search, page 53.
83.
Yes, 53, my lord.
53.
Lord,
Yes.
Deserted from colonial line 14/10/2010 to about 17 hours, my lord. My lord.
That is it, right.
Yes.
1410
Yes.
and is still absconding.
Yes,
Okay.
my lord.
Then
before, the page 42, kindly, consider, page 42. This is the, he was granted leave,
For period
for period, it is mentioned, it is informed that you were,
6-1 to 4-2.
yes,
So, but then this article says with effect from 14-10-10.
yes, my lord.
So how does page 42 have any relevance in context to this?
Yes, my lord, relevance I want to place, my lord. Para 4 of the repetition I have stated, he sustained injury in an accident. My lord, page 4, para 4, my lord, page 27. And for treatment, my lord, 30 days leave was granted for this purpose, my lord. My lord, now inquiry report, kindly see, my lord. Inquiry report is at page 59, my lord.
Yes.
My lord, on only page 59, my lord, para 2, only once, my lord, he appeared in the inquiry on 25/6/2011.
He then absconded
Yes,
again.
yes, yes,
Then
my lord. And then, my lord, page 60, para 6, my lord. This is an important one. May I read this, my lord? On analysis of the evidence, it is found that there is no information as to why so-and-so Pankaj will be absconded from the camp line and how. Whereas on the basis of the statement of Constable Pankaj Borua, it is learned that he did not know anything as to what had happened to him due to his mental state of illness. My lord, now other evidence kindly see page 61. My lord,
yes.
last 2 paragraph, my lord.
Yes.
Page 61. On the basis of witness number 1, 2, and 3, Constable so-and-so was found to be obedient to his duty, but no information could be found as to why he had absconded. My lord, my case is that, my lord, unauthorized absence is there, my lord. Unauthorized absence is there on my part, my lord. I was suffering certain treatment and undergoing certain treatment to that substantiate that
No such medical record was placed on record of the
My lord.
inquiry.
My lord,
So the treatment.
My lord, now my case is that, my lord.
Yes.
My lord, as per the decision of Kusan B. Parmar, 2012 CSCC 178, my lord, there, my lord, may I place these judgments, my lord? There, my lord, it is held by the Honorable Supreme Court in a case of unauthorized absence. There may be absence or unauthorized absence, but those absence must be proved as willful, my lord. My lord, so far I am concerned, there is no willful act on my part, my lord. I was suffering, my lord. And the perversity of the Honorable learned single judge that, my lord, the inquiry officer has not held that the absence is willful.
Let us see the conclusion.
Yes.
Let's.
From the inquiry report, my lord.
Where is it?
Page 61, last paragraph. On the basis of evidence number 9, after Constable Pankaj has been served a notice of the by the IO, he appeared before IO at the preliminary stage of investigation, but on 19/7/2011, he again absconded before the completion of investigation. After that, he neither appeared before IO nor communicated with him. From the statements of the accused and the documents submitted connected with search level against so-and-so, and the accused appeared before IO and had been served notice by the IO, but again absconded before completion of investigation. It seems the constable so-and-so does not want to rejoin.
Willful absence from duty is not the conclusion as per.
Yes, my lord. And my lord, the charge also not to that effect, my lord. My lord, the conclusion of the learned single judge, my lord, kindly.
Let us see. Where is it?
My lord, para 12, 159, my lord. My lord, here para 12, it is referred to the medical certificate wherein it is found, my lord, he was not suffering from psychiatry, but for mental stress, he was admitted there, my lord, in the test for mental health college. And now, my lord, para 13, my lord, 160 page, my lord. Though the petitioner's counsel has submitted that there is no finding by the inquiry officer the petitioner willfully absent, the fact that the medical certificates that the petitioner did not suffer from any psychiatric illness during the period of absence implicates that the petitioner was never having any mental disorder imbalance. As such, the only implication that they can arise from the above is that the petitioner was having normal mental capacity and has remained willfully absent. This finding perverse.
Mr. Chaudhary, single judge was not supposed to substitute his own wisdom for the wisdom of the inquiry officer. Where is the finding? Where is the charge of willful absence?
Let us not go into that. Let what man show that he was not willfully.
Mr. Chaudhary,
Here is
this is a disciplinary inquiry.
Yes.
You have to have a specific charge. What is the charge? Read. Is the charge of willful absence, please? Read. You are putting the cart before the horse.
Now here is the.
Charge, page 54,
Page 50.
53, 54, both read. Willful absence from duty.
That said so and so while functioning.
Still,
Has committed an act of misconduct.
he has been declared as a deserter. Where is that declaration?
He has been declared. as-
Where is that declaration?
Flush, that is.
Let's see. The declaration that he is a deserter. Yes. Where is it?
That is that.
My lord, I have enclosed that, my lord, page 50, my lord. My lord, in the petition, I have silenced this also, stating that this has been done behind my back, no allowed to participate. And in fact, the present inquiry also, my lord, this is expertise. My submission is that, my lord. My
Why
lord,
is it expertise? You appeared, then you did not turn up.
only once, my lord, and my lord, it is stated in the order itself, my lord. My lord, page 69, my lord. Last line, my lord.
Hmm.
Page 69, my lord.
Yes.
Last line, my lord. Hence, there was no other alternative with the inquiry officer except conduct the inquiry ex parte. My lord, in any case, this inquiry was ex parte. And my submission is that, my lord.
Where is, how do you say? Expertise? You
Yes,
did not,
yes,
you did not appear. What to do then? They recorded evidence.
my
It's
lord.
not the case wherein that they did not record the evidence.
Yes.
They recorded evidence. So ex parte inquiry can be conducted. What is wrong?
No, yes, my lord, but no sons of my lord, consequences, those are I.
That's your responsibility. You did not choose to come.
My lord.
They informed you.
My lord, may I sum up my argument, my lord?
Yes.
My only three judgments, my lord.
Read.
Here, my lord, can you-
Does any of these judgments deal with the situation wherein the army man has been declared to be a deserter?
Oh, yes.
The absconding armed force personnel has been declared to be a deserter. And his intention is writ large. He does not even come up for the inquiry. There is no medical report.
My lord, therefore, my lord, he was admitted before the my lord, mental health.
There
My lord,
is
finally mental
no
health-
document. Which is the document is
Yes,
supported?
yes, that is,
Let's see.
and
A man may,
my lord, page 49, my lord.
a man may decide, choose of his own doing,
My
go and get admitted, even though he is not suffering from any mental ailment.
My lord, yes, my lord.
Yes.
Page 49, my lord, this is the document we placed, my lord.
Get it?
Yes, this is the certificated Pankaj Besbura, so and so, district nobody has admitted in this institute on 2010-2011 for diagnosis and treatment, but he got discharged on his request on 7/11/2011.
Chapter closed.
And my lord, this communication was forwarded to the authority, my lord. And while filing appeal, my lord, they were
This
supposed
is-
to consider,
Gentlemen,
my lord.
this is of October 2011.
My
He
lord,
was
after that,
absconding from October 2010.
my lord.
So what about the previous period?
My lord, in para 4 of the writ petition, we have specifically stated in December 2009, my lord. He suffered. an
Writ petition stating in writ petition is of no value
My lord.
unless you support or substantiate that averment by documents.
My lord, this is to substantiate our some medical ground was there. My lord,
That's just,
now kindly see, my lord,
yes.
from the judgment, my lord, if I may satisfy your lordship, my lord. 2012 3 SCC, my lord.
Read.
Para 16, my lord. In this is also my lord, unauthorized absence. Here is my lord, for a period, para 11 for a period 234 days. And
Yes.
para 16, my lord, in the case of appeal and appeal referring to unauthorized absence of disciplinary authority, alleged that he failed to maintain devotion duty, his behavior was unbecoming the government servant. The question whether unauthorized absence from duty amounts to failure.
This is a
devotion
case
duty
wherein
or
the
behavior of
employee,
government servant.
Mr. Counsel, this was a case wherein the constable was requesting the authorities to transfer him to some other place. That was the case. There was a dispute because of that.
Here is.
That is the background.
Another.
Read para 12. Read para 12.
I will, prior to para 11 kindly, my lord.
And the period is hardly anything.
Para 11 kindly, my lord.
Yes.
I will, para 12 also, my lord.
Yes.
The appellant was principally served unauthorized absence from duty during 3 consecutive periods. So and so, total 234 days, my lord. Yes, my lord. In this connection, para 16, 12 also, my lord. Para 16 and 17, 18 and 19 important, I will be reading, my lord.
Yes.
17 now, my lord. If the absence is a result of compelling circumstance under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application of prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such case, an employee cannot be held guilty for failure, devotion to duty, or behavior unbecoming a government servant. 18. In a department, if allegation of absence from duty is made, the disciplinary authority is required to prove the absence is willful.
Here, there is a multiplicity of these factors because your client does not even turn up for the inquiry. He once comes, then again he goes off.
My lord.
So that what does it show? What more evidence of willful disappearance from duty do you require?
My lord,
What more is willful? He is not,
specifically-
he is impudently, he just ignores the inquiry proceeding. What more?
My lord,
These are discipline forces.
my lord, next judgment.
Yes, please.
Here, my lord.
Which one?
R.K. Sharma, Union of India was R.K. Sharma, my lord.
Yes.
Page para 9, 10 and 11, my lord.
Yes, read.
Yes. My lord, directly to paragraph 11, my lord. As regard to the period for which the respondent was absent from duty, we are satisfied that the punishment dismissal from service is too harsh.
That was in a peculiar facts. What was the period? Here the period is too long, sir. Even in
Yes.
that case you are referring to,
Yes.
this period is hardly 2 months. Here it is more than 1 year.
My lord, I will try by another judgment of 2009, my lord. Here
Yes.
period is 6 months, my lord. Can you please read me?
Here it is beyond 1 year, sir. Not only the charge sheet,
Yes.
even during inquiry.
My lord, my para 19, 20 and 21, my lord.
Read, please.
The doctrine of proportionality.
And this
on
is
the-
not
on
a case of,
proportionality.
this is not a case of disciplined forces.
Yes.
That 2009 is not a case of disciplined forces.
However,
So it
my
makes
sub-
a huge difference.
However, my submission is that, my lord, in a case of unauthorized absence, my person may have difficulty, my lord. He may.
There is no presumption that he had any difficulty. The presumption is to the otherwise.
Moreover, kindly now, my lord, kindly refer to, my lord, CRPF Force Act, my lord, 1949.
Read.
My lord, in a case of unauthorized absence.
Yes. CRPF Act then. Yes.
Absence himself without leave or without sufficient cause of overseas leave granted to him. My lord, this amounts to less heinous crime, my lord, as per this, my lord, section 10. And here, my lord,
Let's see. There is one more. Section 11 also read. What does section 11 say?
yes, this is minor, but here, my lord, dismissal also there, my lord. But if it is a case of absence from duty, my lord, there, my lord, it is stated, shall be punishable with imprisonment for time which may extend to 1 year. Or with
So it's a
fine,
punishable crime.
my lord.
It's a punishable crime.
My
Why
lord.
should the employer keep on hanging the or dragging the employee with himself? And
My lord,
disciplined forces.
My lord, so far this is concerned, my lord, that he had some ground, my lord, for
Okay, very well.
absenting duty. my lord.
Okay, let Mr. Chaudhary have a say in this. Yes. Yes, Mr. Chaudhary.
Lordship,
Where is the finding of willful absence?
Yes.
Lordship, willful absence is supposed.
Then how could this penalty have been imposed?
Lordship in kindly speak.
Mm.
When the proceedings were there, he has participated, thereafter he has not.
So assuming,
Now, when does he wake up, Lordship? He wakes up in 2017. He wakes up in 2017. And then he files an appeal.
Files the appeal.
Files an appeal
Okay.
in 2017.
You did not dismiss the appeal on ground of time barred.
And now,
Hmm.
the only point that he had argued before the learned single judge was on the medical. He does not submit anything on the procedural part. There is nothing on the procedure.
No. Read para 13. Para 13, how the learned single judge deal with this argument. This is contradictory finding.
Yes.
Para 13 and para 14,
Flush.
the findings are contradictory.
Yes, flush.
Let's read the inquiry, the writ petition also.
Flush.
There are specific grounds.
He has lordship to her. He has not argued all this.
Para 13, the argument is there.
Yes.
Talking.
No, before the single judge lordship, he has made some amendment in the petition.
Para 13 of the order.
I've seen that.
So the argument is there. No finding, willful disobedience. That is what his argument is.
My
Flush. That is there. That I.
So this is a contradictory finding in the learned order of this learned single judge. Para 17 of the writ petition, read. So then we can remand the matter to the single bench. Let the single bench decide this argument.
That part he has to.
No, entirely.
All right. We'll remand the matter to the single bench.
My
Your opinion held in paragraph 13 is that then say amount to wait. No such no finding. No dealing with that.
yes, correct.
Regarding non-available, whether the penalty can be disposed of.
Not obliged, madam, deeply obliged.
Yes.
My lord. In this case, I'm led by senior counsel. He was here, my lord, because of a matter. He has gone, maybe timing, first of all, for the timing, my lord. This is a railway appeal.
Appeal against what order?
My lord.
What is the
Single judge order, my lord, at page 13.
31. 31.
acquisition?
No, my lord, here it is a case where the writ petitioner approached this honorable court for a direction that their land has been encroached by railway.
Encroached by the railways.
And the claim is on the basis of.
Let it come up in the next week, list next week as per it.
My
Item number 86.
May I please your lordship.
Yes.
This is a case of recovery allegedly for overstaying here.
Overstaying?
Overstaying in my service.
Oh. Okay. Hmm. Yes.
We challenge the judgment because, my lord, this judgment is of very peculiar nature. We cannot criticize a judge, but the judgment is insulting to the petitioner's counsel. Because I have never come this type of judgment in my 50 years of career in this profession.
What part of this judgment you are aggrieved by?
Because the last part, my lord, last one. I'll come to the other paras. That is para 16. Para 16. as your lordship got it.
Hmm.
The court is satisfied that the recovery is made and sought to be made from the petitioner has been ordered at the own request of the petition. None of the cases cited by the learned counsel for the petitioner would come to the aid of the petition.
Yes.
The reason for arriving at the said conclusion is that by writing dated 22/3/13, the petitioner has been successful in persuading Deputy Commissioner an order official Jorhat Treasury not to prosecute him on allegation of various criminal offenses committed by him and to take lenient view because of the offer made by the petitioner to recover overpayment. Therefore,
Hmm.
there
Yes.
appears to be no good reason
Yes.
to burden this order with discussion of 27 cases cited by the learned counsel for the petition.
Right.
So, because the distinguishable fact that the present case in hand has already indicated that the petitioner had come,
Yes, please.
not come with the clean hands and surprise his letter dated 22/3/13.
Yes.
Below these 27 cases I have cited on different points.
Hmm. Yes.
Now,
So even if the judgments don't apply, the learned single judge is required to deal with every judgment which is cited. Even if the judgments are distinguishable, every single line of the judgment is
But-
required to be dealt with. And if it is not dealt with, it is an insult to the council. All
my
right, sir.
lord, now, may I submit, my lord?
Yes, yes, please carry on.
Or at least one or two lines could have been discussed.
All right,
Why I have referred these cases.
right.
The second para 10 of this judgment, my lord, how?
Any of the judgments which you cited, Mr. Counsel, was it having a situation wherein the petitioner had himself made an admission? Yes, please withdraw, recover this amount from me.
That is the another issue, my lord, so far as para 10 of the judgment, my lord.
Yes, please.
This is the case of the famous Rafi Masjid state of Punjab.
The Rafiq Masih, yes.
Yes. Because the learned single judge had not discussed about the parameters fixed by
Hmm. Yes.
the honorable court about the situation,
Yes.
what to take and what not to take. So with that,
Yes, yes.
Sir, in this, my lord, in this matter, lordship, I was appearing before the learned single judge,
Mhm.
and I still lordship finance is the party here, lordship. But my name is not reflecting in the cause list, lordship. So just now I came to know about this.
Name of Mr. P. Nayak, Standing Counsel, Finance Department shall henceforth be reflected in the cause list. The matter shall be re-notified after 1 week.
Item number 87.
Yes.
May it please your lordship. Lordship, my lordship, the petitioners herein, my lord, they're working in different capacities as stenographers and in grade 4 post.
Hmm.
My lord, what had happened is, my lord, they were applied for against a regular sanction post. Thereafter, my lord, they had paid for regularization of their service.
Hmm.
And however, the regulation did not happen and their prayers were not, all the prayers were not considered. So they went to the Supreme Court. The Supreme Court gave a liberty to file a review petition.
Mhm.
That the judgment of the review petition is at page 75 of my writ appeal, my lord.
You have the copy of the affidavit which has been
Yes.
filed today or yesterday?
It was filed yesterday, lordship, I received copy today.
All right. Are you prepared in view of what has been said in the affidavit?
Yes. It
Oh.
is, lordship, out of the 8 petitioners, 3 has got the benefit. And in my submission, lordship, 2 are not entitled to those benefits of the
Mhm.
finance department notification. Was in.
All we are asking you,
Yes.
you would not seek time once the matter is being argued. All right.
My lord, at page 76, my lord.
Yes.
my lord, on 16/12/2016, for amicable settlement of dispute of the review petitioners, the learned senior additional advocate general made the following offer, that their service will not be dispensed with, but for
You're
disciplinary
reading
action.
from the judgment
75, my lord, review
Yes.
judge, review. petition.
review.
Yes. Page 75, man.
Right, okay.
Or last part, my lord.
Mm.
That their service will not be dispensed with, but for disciplinary action till they attain the age of superannuation,
Mm.
till they will be paid wages minimum of the regular pay scale,
Mm.
that at the time of the superannuation, they will be bought another medical insurance scheme.
Okay.
So we agree to the first two conditions, my lord, but with regard to the third condition, the liberty was given to us to file a representation
Hmm.
before the Department of Pension and Grievance, and accordingly we filed a representation. However, our representation was not considered.
You were asking for pension benefits
Yes,
also.
we were asking
Okay.
for pension benefits. So
Okay.
that pension benefits was not granted to us.
Hmm.
And that speaking order is at page 83, my lord.
83 read. Yes.
Pension and Public Grievance Department, my lord, that it may be mentioned herein, my lord, at the fourth paragraph, my lord. It may be mentioned herein that since the petitioner are not regular employees of the state government, Judicial Department is not in a position to extend benefits of pension as well as medical benefits to the petitioners. Both these benefits being regulated by respective rules, the Assam Service Pension Rules and AMA Rules 2008, wherein no provisions for granting these benefits to casual employee exist. However, to take a decision on the matter, we have requested views, advice from the Pension and Public Grievance Department as well as Finance Department. The views of the department are here follows. Pension and Public Department, after careful observation, advises to take the matter with the finance existing under the ASAP Rule 97 do not cover of the instant case. And with the Finance Department is that as per PNG views of the claim the petitioner do not cover by the existing provisions of the Assam Service Pension Rules of 1969. Hence, the Finance Department is unable to consider the proposal. As per the above observation of PNG Department, it is clear that the petitioners are not covered by the existing provision of Assam Service Pension Rules. Hence, in view of the above, Judicial Department is not in a position to grant the benefits claimed by the petitioner.
Okay.
At the bottom, in the meantime, it has come to the knowledge of the Judicial Department that in pursuant to the order of the Honorable High Court, in writ Appeal 45 of 2014, the state government has constituted a committee which will examine inter alia the issues of granting health and accidental death insurance scheme. The committee will suggest further course of action towards the compliance of the Honorable High Court in order so and so, which includes inter alia implementation of measures and cover the master role, worker charge, and other similarly placed employees.
Yes.
So thereafter, the next paragraph, accordingly, Judicial Department has collected information of such employees who worked in subordinate judiciary from the registry of the Honorable Guwahati High Court, which includes the service detail of the petitioners also. The name along with the service detail of the petitioner have been submitted to the committee for recommendation regarding health and death insurance scheme. Whatever benefits the committee recommends as regards the medical, the same will be equivalent to the petitioner also. And thereafter, my lord may see at page annexure 8 at page 85, my lord. As per the review judgment that is in page 75, one of the petitioner, my lord, he was been receiving, this is of me, this is of the salary statement from September 2017 to May 2018. He was receiving his basic pay, his DNS allowance, his HRA allowance, his special pay allowance, and his medical allowances. However, without any order of this honorable court and without any order of the department, they refused to pay us any allowances from Feb 2018 onwards. So being aggrieved by that, my lord, we preferred a writ petition before the Honorable High Court. And a single judge judgment is at, my lord, at page 147, my lord. And the judgment starts at 150. The effective part of the judgment is at page 11, my lord. That in support of his submission, the learned counsel has relied upon the case of state of Punjab and Jagjit Singh, which is reported in reported in 2017 1 SSC 148. The Honorable Supreme Court in the said case was dealing with the issue of entitlement of temporary employees and was held that they would be entitled to draw wage at the minimum of the pay scale in a regular pay scale, which are extended to regular employees holding the same post. For contrast, CP Nayak, Learned Counsel, Standing Counsel, Judicial and Finance Department submits that the writ petition structured on the basis surmise and conjure which an issue which has already been set to rest finally by earlier orders of this court, including the Honorable Supreme Court, has sought to be reopened. It is submitted the present attempt is nothing but afterthought, and which is not permissible under law, and guise of failing to settle issue have been attempted to unsettle. My lord, then at paragraph 15, that, sorry, my lord, at paragraph 19, at page 154.
Yes.
194, man. The case of Jagjit Singh Supra cannot be a universal application, as in a case in has a checkered history, wherein the writ petitioner was dismissed at the first instant and matter was reopened only upon the observation made by the Honorable Supreme Court. Further, the subsequent order passed by the divisional bench 23/1/2070 is upon a consequences made. Though the powers conferred to the is an unlimited one, the settled law does such power to exercise with self-imposed restriction. The scrutiny of a writ court is confined to decision-making process and not to a decision. My lord, this I am affected with. My lord, this is a service matter, my lord. Here in the service matter, service jurisprudence is clear here that even the decision-making process and the decision has to be settled, right? And with regard
All
to
right, but the issue is, gentlemen,
yes, my lord.
that your first round of litigation,
Yes, my
you
lord.
lost.
Yes, my
The
lord.
ultimate what you got in the review
Yes.
was just in a concession kind of thing.
Yes, my
So
lord.
how can you reopen the proceedings
No,
again?
my lord, my lord, my
Let us see the first round of judgment.
yes, my lord.
First judgment in your case. What was the relief sought for? Where is that judgment? 60?
Page 60, my lord.
Yes. What is the prayer?
My lord, having pursued the pleadings of the party, the materials are recorded, page 63. This court was established on a specific scheme, initially a period of 5 years. Subsequently, this court were made to continue. While the first track court has been functioning, the government of Assam, following certain directions which were given in Brij Mohan Lal's, are made by notification dated so and so. And my lord, then at page number 64,
Yes.
with thus no mandamus can be issued directing the state government or any authority to either absolve the petitioner against the said sanction post or appoint them afresh against the said sanction post,
Yes.
which has been as indicated sanctioned for making the said 20 course functional.
Yes.
It is hereby made that the petitioner may subject to the provision of the relevant requirement have been sanctioned by the state government. And if they or any of them make any application pursuant to the selection process, which may be restored to her filing of the said sanction post, the case of the petitioner shall be considered a case of any other candidate, prove that they are found otherwise eligible to participate in selection process.
Yes. So your appointment was never treated to be a regular appointment. Even in the SLP, the prayer which was made was to fix the pay scale at the equal pay scale of a regular employee.
Yes, my lord.
Not in the grade. You are not to be taken into the grade or the cadre of the stenographers.
No, my
There
lord.
was no such prayer even.
No, my lord.
Or if such prayer was there, it was not accepted.
Yes,
Your appointments were coterminous with the constitution of the first courts, which came to an end. It is only by way of benevolence in the review that a kind of arrangement was made that you will continue in the minimum pay scale and you will be given the medical benefits.
Yes, my lord, this minimum of the regular pay scale is inclusive of allowances. And I am, yes, my lord, because as per the Jagjit Singh judgment 2017 1 SSC, my lord, 2017 1 SSC, my lord.
Sir, read the review judgment. Does it leave any scope of reopening the proceedings on this count?
Yes, my lord, because that they will be paid wages of the minimum regular pay scale.
Yes, minimum.
Yes, a minimum
Yes.
regular pay scale has been established in 2007 1 judgment, my lord. It is here-
Wages, only wages,
Yes, my lord.
no allowances.
My lord, my judgment is, my case is covered by this judgment, my lord. May I just refer to a judgment?
Read.
2017 1 SSC, my lord.
Yes.
There were two sets of employees that were there before the Supreme Court. First were the ad hoc employees. For that, the Supreme Court honorable categorically stated, page 148.
Yes. Before that, read the pleadings, the prayer clause of your first writ petition. Do you have the copy?
No, my that copy, my lord, I am here on the issue that that as per the review judgment, that a minimum of the regular pay scale is inclusive of allowance, my lord. And I'm affected by this, by the after effects of happening of this judgment, where the interpretation of the regular pay scale would scale itself inclusive allowance, my lord. Even the law, the wages of the law dictionary, if it includes all remuneration, my lord. Even the 2017 judgment has cleared it, my lord. My lord, may I just at
Yes, read.
Now at page 55,
155.
Page
Page 55.
sorry, ma'am, at page 224, the last page.
2 to 4. Yes. 2 to 4.
Yes.
Of which judgment?
No, 148, 2017, 1 SSC 148 is a judgment. Jagjit Singh.
Yes. So
Yes, the 2 to 4 page, ma'am, like my lord. 2017, 1 SSC 148.
2 to 4.
Yes.
Right.
In view of the position expressed by the foregoing paragraph, we have no hesitation in holding that all temporary employees concerned in the present bunch of cases would be entitled to draw wages at the minimum of the pay scale at the lowest grade in the regular pay scale extended to a regular employee holding the same post. So I am entitled for my allowances, ma'am, because my lord, in this bunch of petition, there were two kind of repetition that were filed, and that would my lord would file at page 5. Sorry, page 162, paragraph 5.
Yes.
That the issue which arises, may I read, my lord? The issue which arises for a consideration is whether temporary engaged employees, daily wage employees, ad hoc appointee, employee employment casual basis, contract and the like are entitled to the minimum regular pays along with dearness allowances revised from time to time on their performing the same duties which are discharged by those engaged on regular basis against sanctioned posts. The full bench of the High Court, while educating upon the above controversy, has concluded that the such like temporary employees were not entitled to the minimum regular scale merely for reason.
So where is the observation of Supreme Court on allowances?
My lord, on that observation only, my lord, that is what I'm saying, my lord, at page 50, at page 222.
Yes. Yes.
Page 55, my lord.
Para 55.
Yes, in view of above consideration, the decision rendered by the full bench of the High Court in so and so, the decision rendered by the division bench of the High Court in state of Punjab and Ranjit Singh, we affirm the decision of Senator Ranjit Kumar with the modification and would be entitled minimum of the pay scale of the category which they belong, but would not be entitled to allowance attached to the post by therein. My lord, thereafter the paragraph, we shall now deal with the claim of the temporary employee before this court. And the claim of the temporary employee was decided by paragraph 61.
Yes.
Where they have said that employee concerned in the present bunch of cases would be entitled to draw wages at the minimum of the pay scale at the lowest grade in the regular pay scale, extended to regular employees holding the same post. So we have been performing the same duty, same work hours, and we will be working for there till we attain the age of superannuation. So only benefits that the Jagjit Singh and this judgment also gave was the minimum wage of the regular pay scale. So we will be fixed to the minimum scale, but the allowance is inclusive of all the scale.
Yes, Mr. Nayak, what to say? What about allowances?
May straightforward come to the judgment part of the Supreme Court in Jagjit Singh.
Yes.
4 paragraphs I am reading. Lord.
Right.
May come to paragraph 5.
Para 5. Yes.
Here, the issue which arises for our consideration is whether temporary engaged employees, daily wage employees, ad hoc appointees, employees appointed on casual basis, contractual employees, and
What is the nature of their employment as per you?
that was the issue.
What is the nature of employment of these petitioners? Contractual. All right.
So this was the issue before the before the Supreme Court. Then Lordship may come to page paragraph 43.
43.
Page 209.
Yes.
Paragraph 43. We shall now venture to summarize the conclusions recorded by this court with reference to a claim of pay parity raised by the temporary employees, differently designated as workers, daily wage, casual, ad hoc, contractual, and the like in the following two paragraphs. I am coming to Lordship paragraph 46. Lordship various citations were placed before the court, and 46 Lordship will see the last 3 lines. Paragraph 46.3. Last 3 lines, Lordship. We would therefore be obliged to follow the large number of cases where pay parity was granted rather than the instant singular judgment recording a divergent view. Then the final conclusion will find Lordship at paragraph 55.
Which was highlighted just.
Paragraph 55.
Right.
222.
So you are trying to distinguish them from temporary employees.
No, Lord.
They are not temporary employees.
No, Lord. Can kindly see the paragraph 55 Lord.
Mm.
In view of all our above conclusions, the decision rendered by the full bench of the High Court in after seeing state of Punjab dated so and so is liable to be set aside.
Mm.
The same is hereby set aside. The decision rendered by the division bench of the High Court in state of Punjab, Rajendra Singh, is also liable to be set aside, and same is also hereby set aside. We affirm the decision rendered in state of Punjab, Rajendra Singh, Rajendra Kumar, with a modification that the employees concerned would be entitled to the minimum of the pay scale of the category to which they belong, but would not be entitled to allowances attached to the post held by them. So that is the general conclusion, Lordship.
Mm.
Next paragraph, Lordship will file. We shall now deal with the claim of temporary employees before this court.
Mm.
They are the petitioner. And why the relief was granted, that is paragraph 60.
Mm.
Next, 2 to 4, Lordship, in the middle portion, Lord.
Mm.
However,
Yes.
However, insofar as the instant aspect of the matter is concerned, it is not difficult for us to record the factual position. We say so because it was fairly acknowledged by the learned counsel representing the state of Punjab that all the temporary employees in the present bunch of appeals were appointed against posts which were also available in the regular calendar. The case of the petitioners in that case, Lordship, with the learned friend is relying, Lordship.
Those were,
is
they
not
were
applicable
working
in the
against
present case.
encadred posts,
Yes,
temporarily appointed against encadred posts.
yes.
But
And that
these
provision-
petitioners were not against any encadred post.
Yes, Lordship. That is why in his case, Lordship, paragraph 55 is applicable,
Mm.
not paragraph
Right.
60, Lordship.
Mm.
One more judgment, Lordship, I'm placing, Lordship.
Mm.
2006 9 SCC 337.
Mm.
Page 337. Paragraph 5, Lord.
Yes. Mm. Mm.
339. Here it is.
Mhm.
Paragraph 5. In several cases, this court applying the principle of equal pay for equal work has held that daily.
They are not daily wages. Were they on daily wages?
Lordship court directed him, Lordship will kindly take page 71 of the appeal order part of the London Division Bench.
Yes. But then they were not treated as daily wages, no?
They were directed to give wages at the minimum of the pay.
But not daily wages. This judgment relates to daily wages. How does this apply? They were muster roll employees. This judgment would not apply. They are not on daily wage.
And paragraph 55 is applicable to them.
That's your argument, we'll see. Yes.
Yes, my lord, may I just submit here, my lord? My lord, before,
Subsequent there to law.
Yes, yes, carry on. You finish
Yes,
first.
subsequent to here to law. Lordship will kindly see the speaking order passed by the division law, by the department at page 83 law,
Mm.
page 83.
Yes.
Last line law, last paragraph law. In the meantime,
Mm.
it has come to the knowledge of the judicial department that in pursuant to an order of the Honorable High Court in WN number 22, the government of Assam has constituted a committee which will examine inter alia the issue of granting health and accidental and death insurance scheme. The committee will also suggest further course of action toward compliance of the Honorable High Court order in W 45/2014, which includes inter alia implementation of measures of covering the master roll worker and other similarly placed employees in health and accidental and death insurance scheme for the matter before the cabinet.
Mm.
Accordingly, judicial department has collected information of all such employees working in the subordinate judiciary from the registry of the Honorable High Court, which includes the service details of the petitioner. Also, the names along with service dates of the petitioners have been submitted to the committee for recommendation regarding health and death insurance scheme. Whether a benefit The committee recommends as regards medical benefits and same will be equally applicable to the petition. That pertain to this order, Lordship. In my last affidavit, your Lordship will find, there I have mentioned that except appellant number 1, Lordship got the benefit.
Of medical and health insurance.
Even allowances.
All have been given. Why then?
In
Why you excluded one?
Not if it's subsequent law. My affidavit states, except
But then why you have excluded one petitioner?
Lordship, in his case, Lordship, the scale in respect of which Lordship these benefits were given, he is already getting more than that.
You have pointed out that distinction in your affidavit. Why you have not given him that benefit?
Yes.
Where do we read from your affidavit?
In 161 law.
Yes, please.
Number 161, paragraph 6.
Yes.
The writ appellants except the writ appellant number 1 got the benefit of minimum of the pay scale, which includes unit and medical allowance of ₹600 in terms of the finance department. So and so. Whereas writ appellant number 1 did not get any further benefit in terms of the paid notification, as he was already doing the minimum of pay scale of 14,000 plus grade pay of 7,400, that is 1,400.
All right. Yes.
Others have got the benefit of allowances, medical allowances.
That is what they have elaborated. Yes. That is what they have elaborated. They have given out his. What do you say after this affidavit?
Yes, my lord. Before I go to my affidavit, my lord
Yes.
just made glance at page 117 of my writ appeal. It's a notification by the government. 117, my lord.
Yes. You better take rest. Take rest. Take rest. Take rest. Yes.
The following, may I read, my lord? The following are hereby notified for compliance by all state departments as applicable for the master role, work charge, casual and a similar place employee who are appointed to FRBM period, that is 1st September 2005. Government notification, minimum pay scale pay band 1, 12,000 to 7,500. This pay band 1 is for a grade 4 employee. It is not for a stenographer, my lord. My petitioner number 1 is a stenographer. And as per the Jagjit Singh judgment, I should be getting my minimum scale of the pay band that I'm working into. And my pay band is, my lord, I have clearly stated in my affidavit. And even I have given my salary statement also. My lord, at page 171, continuous.
You are getting 14,000.
40, no, my lord.
Read their affidavit, please. Plus grade pay of 7,400. Read page 162. Bottom line. 14,000 plus grade pay 7,400. So it is there on a higher grade pay.
Yes, my lord. Notification number, whereas the writ did not get any, as he was already drawing the minimum of the scale. So this I'm already drawing. So that does not entitle me to not to get my allowances, because this is a scale that I'll be stagnant for my entire life. No, because this is a pay band. This is the pay
Why
band.
allowances will not be admissible?
Yeah, this is a pay band that I'm in fixed.
Allowances, Mr. Nayak. Allowances will have to be given.
Multiple candidates. This is not the only case. There are several other cases. Multiple once again see the issue before the Supreme Court. In Jagjit Singh law. Once again, paragraph 5.
But then you have granted benefit of allowances. Why do we need to go to Jagjit Singh now?
Order passed by this honorable court.
This court simply said, you give them minimum of pay scale. Then you were benevolent enough, you granted pay scale and the allowances to all others. Why you exclude one? What is the reason? There is no apparent justification, and they are doing their duty. The courts will be paralyzed if these people are not there.
I understand what your lordship is suggesting, but the problem will be, lordship, if I give this benefit to him, lordship.
You are giving to how many petitioners? There are how many petitioners?
8 petitions.
8. You are giving to 7.
Yes.
So why exclude one?
Not
because they are included in that pay scale.
The petition number 1 is a stenographer. The others are grade 4 employees.
Yes.
So he will get the allowances of a stenographer. If grade 4 employees are getting, why you exclude the stenographer?
Whatever benefit has been given, lordship, it was pursuant to a court's order.
That court's order,